Hi, Greg Dell with Dell Disability Lawyers here with attorney Stephen Jessup, and some of our favorite videos are to talk about successful cases we've had, and here today, Jessup, we're going to talk about one of your cases against Hartford. So give us an idea of the background of this case, and let's take away some tips from this case that people can benefit from, and also maybe give them some things too where they can learn what it takes to avoid a denial and learn how we can help them to get their benefits reversed if they've been denied.
Yeah, so this case was with Hartford, as you said, but like a lot of people, it was originally an Aetna policy. And then Hartford, after purchasing Aetna, on the disability side, took over the handling of it. So the client was a former in-store merchandiser for Home Depot. So he had a very physically demanding job, setting up displays, moving, merchandise around, all types of various things like that.
Right, we've had a lot of Home Depot clients.
A lot. I mean, they're such a large employer, you're going to get a lot of people out of there. So he originally filed for disability on his own. In one of those situations where he did have pain conditions related to his lower back and then hip problems, to the point that he's in his early 40s looking at potential hip replacement. His hip is so bad, but then also mental health issues, and the mental health issues are severe in and of themselves. Aetna, prior to Hartford taking over, initially approved his claim under the mental health provisions. Hartford took over with the administration of it, and unlike most policies, this Home Depot policy, and I don't know if they've changed at this point, but his only has 18 months of own occupation protection. So it was a weird situation where he has a 24-month mental health limitation, so there's a weird 6-month gap between the change from own occupation to any occupation and into that switch to the end of the mental health limitation. Well, Hartford decided they were going to deny him about 3 weeks to go from that determination of can you do your own job to can you do any job. So that's when he contacted us to help him and assist him in appealing the case at that point. So it posed several issues. One, we had to transition him from own occupation to any occupation. We then had to also establish that the physical impairment was disabling and that the mental health, also, since we have that 6-month gap, the mental health impairment is also disabling, but that the physical would still be strong enough to push him into that any occupation, period of disability.
Okay, so you had, it was very challenging. A lot of people don't know about these limitations and policies, but clearly we usually see the most common reason for a denial is the change from the own occupation to the any occupation. The 18 months is rare. In this case, usually it's 24 months. Yeah. And so that was the first thing you had to tackle, but I guess in the back of your mind you also knew, well, I also still have his mental nervous condition, but I don't want to make that the primary condition because I don't want to get him another 6 months because he's telling me because of the physical, not just the mental, I'm not able to go back to work. So had you gone through and only won on the mental nervous for 6 months, it would have been
we'd be in the same position of appealing and fighting at that point.
So what was your strategy then moving forward in terms of how you were going to attack the physical first?
Yeah, so with the physical, one of the clearest things I thought to do was, functional capacity evaluation. In his situation, the physical therapist that he had been treating with for quite some time did do those examinations, so we coordinated with his actual treating physical therapist to do that. That came back that he wouldn't have a full gamut of light duty. He could do some sedentary, some light duty. Overall, there was an opinion that he wouldn't be able to perform full-time at a sedentary or light duty demand, which, as we know, can be problematic because the insurance companies can write, well, you can do a sedentary job. So we could establish physically he couldn't do his own job, but we only have 3 weeks of own occupation. There was information to say he wouldn't have a full gamut of sedentary or light duty, so work that's not going to be as physically demanding. So that also then necessitated a vocational review to be done to show what transferable skills he has. Essentially, yes, he had some responsibilities in Home Depot, according to his job description, that were like managerial in nature, but the vast majority was physical, and that was the type of work he'd always done. So our vocational analysis showed that based on his training, education, experience, realistically, there were no jobs that had transferable skills that would meet what the findings of the functional capacity evaluation had. So the FCE was helpful, but also required additional information beyond that to just help support not only the remainder of the own occupation, but tackling this any occupation period of disability.
So you retained 2 outside experts to help present additional evidence for the appeal. What was the basis for Hartford's denial? What did they rely upon specifically?
So the big thing is they determined from the get-go that there was no physical impairment. So the denial itself was that the mental health situation had resolved to an extent that he'd be able to return to work. You know, earlier on in the case, there in the medical file, there was suicidal ideation. There was a lot. It was very severe. So they had no issue. But you know, with being out of work and you know the treatment and stuff, there was levels of improvement. So they basically said, yes, you have the condition. We don't think it's as severe as it used to be, so you should be able to go back to work. So even in the denial, they still weren't paying any attention really to the physical problems that he had.
Had he been presenting the physical issues?
Yes.
And what type of doctors was he treating with for the physical?
Physical, mainly he was seeing his primary care doctor. There was a orthopedist who was only doing some SI joint injections, but not much beyond that point, and then his physical therapist.
So because of the fact that Hartford was seeing this as a primarily mental nervous condition type case, how did you get around that in submitting your appeal?
It was the argument from what we had in the medical. You know, comes to learn that even though he had been advising them, you know, he had thought that they were getting those records when he said, "Oh, I'm treating with this doctor," and there were some records in the file.
Records?
Correct. There were some records in the file, but not all of them, especially the PT notes. So, getting all of that information in conjunction with the functional capacity evaluation, and then doubling down with that vocational one, just to you know kind of bolster the strength of the functional capacity evaluation.
Is it common for you to see Hartford at just before the change of definition? I mean, 3 weeks to deny benefits to a claimant?
That's very close, but generally it's common to see them do it, you know, a month or two, several months before. And the main reason being is if you don't know and you just appeal saying, hey, I can't do my own job, you know, I've seen denial letters where they come back and they say, yes, we agree you can't do your own job, but we found other jobs you can do. So they pay the remainder of that. They've just done additional medical reviews and get another bite of the apple because you have to then, you know, submit additional appeals.
Right. So what a lot of people don't realize is that this is a strategic move by the insurance company because they want to cut you off before. Maybe you win your appeal on the own occupation definition of disability. Now they got additional information. They go, you won, here's your 3 weeks of benefits, but by the way, here's additional information. You don't qualify for any gainful occupation definition. Now, appeal again.
Exactly.
So that takes another
6 to 8 months potentially. You know, a person's without money, and in a lot of cases, those people find a way that they have to go back to work because it's a war of attrition, and they can't win it.
So for someone who's watching this video and they know that they're on claim, they're in the own occupation, what kind of tip could you give them to help prepare for the change of definition from the own occupation to any occupation?
You know, I'd say about 6 months out from that. So if you have your standard 24-month own to any occupation definition of disability, at least 6 months prior, the insurance company is going to start pulling records and looking for updates. So you want to make sure that you are still treating. A lot of people are like, listen, there's not much that the doctors can do for me. So if there's not good treatment consistently and they pull those records, they're saying you're not treating. So they'll read that to mean you're doing fine, there's no real issues, or their doctors will say the records aren't documenting, you know, restrictions and limitations severe enough. So making sure you're still communicating with your doctors, getting the treatment, any recommendations that the doctor may have to go see a specialist or anything like that, making sure you're under the idea of an appropriate care of your physician. And then the big thing, especially in a case like this, and it is very common for an insurance company to rely on the mental health as opposed to the physical because of these limitations in the policy. If you were approved because of the mental health and you have physical issues, you need to start fighting that immediately. Right. Immediately. You know, in this client's situation, if they had approved him and said, listen, we still think it's only mental health, I know I still would have, in this case, you know, strange enough, that 6-month gap to continue to fight them on that. You know, thankfully on this one, the strength of the information presented was able to enough for them to approve the remainder of the own occupation, the 3 weeks, and then by the time that the appeal was done and reviewed, I made sure to press the issue of any occupation in the appeal, so they had to take a look at that, and they approved under both.
And how will you be helping the client moving forward now that he's back on claim?
You know, they've already requested updated claim forms, so we're in the process of getting those. You know, and it's that day to day. You know, he does have legitimately disabling mental health conditions, separate and apart from the physical. So it's a lot of stress for him to deal with, a great deal. So we manage it. They have no contact with him. Everything comes through our office. We're trying to, assist. We've gotten him in contact with the Social Security attorney to help him with his appeal on that. Because now Hartford is turning to what's going on with that because they're looking to claw back that money. So it's business as usual. It's business as usual with them. So it's just a matter of trying to protect and avoid, future denials.
Is there any issue that you see the fact that Social Security disabilities denied him, which is a similar any occupation definition, and now Hartford? What if Social Security? What if he doesn't win that appeal? How will that impact his Hartford claim now?
Well, Hartford would certainly try to use that to their advantage. But the reality of it is they try to have it both ways. If Social Security has approved, they'll say, well, Social Security has different standards and we have, different rules in going about it. Well, that's the counter argument. Social Security has different standards. And the biggest reason for him, he's in his early 40s. So just by age alone, there's a greater chance of being denied on it. So it can hurt him, obviously, if he is, and Hartford will come back and take a look at it. But on the flip side of it, I've seen where Social Security is in place, and I've seen savvy claims managers in denial letters cite the judge's opinions from Social Security where they say, well, the judge said you had a light residual functional ability. They still found you disabled. So we actually say, oh, you only have sedentary, and we found these jobs. So they'll try to use whatever they can to their advantage. So it's just being prepared and knowing whatever the outcome may be. And Social Security could say, we're approving you because you're mental health only.
Right.
So there's a lot of ifs, so it's just kind of understanding ahead of time what those roadblocks may be and starting, navigating those waters now.
And I know when I work on those claims in those situations where I have the mental nervous issue, I'll communicate with the Social Security lawyer because we don't handle Social Security
Correct.
disability appeals and say, look, his primary disability is physical and it has to be physical. So even though I know Social Security lawyer, you want to win and get him on claim, if you get him on claim for only mental nervous, that's going to be a negative on this particular claim. So it's very important that we always keep that dialogue open with the Social Security lawyer, and that the Social Security lawyer understands our case, because a victory there could really hurt here, and this case is worth a lot more than the Social Security claim. So there's always constant balance going on between the two claims. So, well, congratulations on this claim, and hopefully the road forward for the client will be smoother. However, as a young claimant in his 40s, you know that Hartford's going to be looking at it several times a year, and that unfortunately there's no guarantee that benefits will continue, but I know we'll continue to help him however we can. So if you're someone who has a Hartford long-term disability claim, feel free to reach out to Stephen, myself, any of our long-term disability lawyers. No matter where you live in the country, we're available to assist you, and we always provide an initial free phone consultation. Hi, I'm Gregory Dell, the managing attorney of Dell Disability Lawyers, and I hope you find the video you just watched helpful. We put these videos out all of the time, and we'd love if you would subscribe to our YouTube channel. Beyond our videos on our YouTube channel, we also have lots of information available on our website at diattorney.com, and we encourage you to come to our website. The goal is that we want you to be educated about the disability insurance process. And when you get to our website, you'll see that we have information all about your specific disability insurance company, your occupation, and your medical condition. And we've designed our website such that you can easily search our website to find things that you may specifically be looking for. Now, at our website, we have thousands and thousands of pages of information, hundreds of videos that you can search. Plus, we're building a section of reviews of all the disability insurance companies, and we have the Ask Our Lawyer section where you can go ahead and ask us any questions that you may have. Now, we realize that you may not need us right now, but you may need us in the future to help you with your disability claim, and we think one of the best ways to keep in touch is by clicking the button below and subscribing to our channel. And most importantly, again, no matter where you live in the country, we're always available. Just go ahead and give us a call. We're happy to discuss your claim and let you know immediately if we can help you.